At 10:18 a.m., the emergency powers that had defined the presidency for months simply vanished. There was no countdown, no televised confrontation, just a notification from the Supreme Court's website and a 6-3 decision that redrew the boundaries of executive authority in real time. The ruling was precise, restrained, almost clinical, but its effect was immediate. The emergency statute the administration had relied on the legal engine behind sweeping executive actions, billions in redirected funds, and rapid regulatory shifts was declared insufficient. The majority opinion contained a sentence that would echo through Washington within minutes. The statute does not authorize this action. With those 7 words, the emergency ended. The vote was 6-3. Chief Justice Roberts wrote for the majority, joined by 5 other justices, including 2 appointed by the president whose power was now being curtailed. The dissent warned of constrained flexibility in moments of national urgency. The majority responded by returning to constitutional structure. Article 1 vests legislative power in Congress. Emergency authority must be clearly delegated. Broad phrases cannot sustain expansive power. The court did not deny that crises exist. It denied that this statute permitted unilateral executive reach at this scale. Within seconds of publication, legal teams across federal agencies began reading the opinion, because the decision did not simply question policy wisdom. It invalidated the authority supporting it. The executive actions taken under the emergency declaration, enforcement directives, funding reallocations, regulatory suspensions were frozen pending further review. Agencies received internal guidance. Halt implementation. Pause execution. Await clarification. In bureaucratic terms, that language sounds procedural. In practical terms, it meant immediate standstill. Programs stopped midstream. Contracts entered suspension. Compliance officers put down their pens. The White House learned of the ruling during a scheduled policy meeting. An aide entered quietly, phone in hand, and whispered to senior counsel. Within moments, the conversation in the room shifted. Staffers refreshed screens. A printed copy of the opinion was requested. The president was briefed. The tone changed from strategy discussion to damage assessment. Because the emergency powers had not been symbolic. For months, they had shaped the administration's agenda. They enabled rapid action without waiting for congressional negotiation. They allowed executive direction to move faster than legislative compromise. Under the declaration, billions of dollars were redirected toward priority initiatives. Enforcement priorities were restructured. Federal agencies operated under a posture of urgency. The emergency was the architecture, and now that architecture had been declared structurally unsupported. In the White House briefing room, the scheduled afternoon press appearance was delayed. Officials prepared statements emphasizing respect for the court while signaling disagreement. The phrase, "deeply disappointed," appeared in early drafts. Reporters assembled with copies of the opinion in hand. Questions formed quickly. Will the administration appeal? Does this invalidate past actions? What happens to funds already allocated? The ruling did not answer all of those questions. It addressed one, authority, and authority is foundational. The majority opinion explained that while Congress may grant emergency powers, it must do so explicitly when the power claimed carries vast economic and political consequences. The statute at issue contained broad language, but not specific authorization for the actions taken. The court applied what it called the major questions doctrine, emphasizing that significant authority requires clear congressional voice. The statute does not authorize this action. That line became the headline. Markets responded cautiously at first. The Dow dipped modestly as traders digested the implications. Treasury yields shifted slightly downward. Analysts debated whether the ruling signaled broader judicial skepticism toward executive expansion. The immediate financial impact was not panic, it was recalibration. Because the emergency powers had allowed swift policy shifts, their removal introduced procedural friction, and friction slows momentum. Political allies framed the ruling as judicial interference in urgent governance. Critics framed it as constitutional correction. But beyond partisan reaction, institutional reality set in. The executive branch must now either seek explicit congressional authorization or craft a narrower legal pathway. The emergency framework that had defined months of decision-making is gone. Appeals may follow. Emergency stay requests may climb back to the justices. But for now, the declaration is inert. At 10:18 a.m., the emergency ended not with sirens but with a sentence. The court did not question the existence of crisis. It questioned the legal bridge connecting crisis to power. That distinction changes everything, because once authority is withdrawn, momentum falters. Agencies hesitate, legislators gain leverage, investors reassess, and presidents adjust. The decision is only hours old, but its consequences are already unfolding. What was once executive acceleration has become constitutional constraint. The emergency powers that reshaped governance for months are no longer operative, and Washington is still absorbing the shock. The emergency had been declared months earlier, framed as necessary, urgent, unavoidable. The administration relied on a decades-old statute that grants the executive branch special authority during national crises involving foreign threats and economic instability. Under that statute, once a formal emergency is declared, the president may regulate certain transactions, restrict financial flows, and redirect specific categories of federal authority. For years, presidents of both parties had used it carefully targeted sanctions, limited economic controls, narrow regulatory adjustments. This time, the interpretation went further. Much further. The administration argued that the language allowing the president to regulate economic activity during a declared emergency gave it broad discretion to reshape entire sectors of policy without waiting for Congress. That interpretation became the legal engine behind sweeping executive action. Billions of dollars were redirected, regulatory barriers were lifted, enforcement priorities were recalibrated overnight. The White House defended its position consistently. The statute, they argued, was intentionally broad. Congress had written it that way precisely to allow flexibility during unforeseen crises. The country faced extraordinary challenges. Speed was essential. Gridlock could not dictate national response. The emergency power existed for this exact moment, but the court did not see it that way. In its majority opinion, the justices stepped back from the policy outcomes and examined the constitutional structure underneath. Article 1 of the Constitution vests legislative power in Congress. That includes the power to raise and allocate funds, regulate commerce, and establish national policy frameworks. The executive branch enforces those laws. It does not create them. That separation of powers is not ceremonial. It is structural. The majority acknowledged that Congress may delegate authority to the executive branch. It has done so many times. But delegation must be clear when the authority claimed carries enormous economic and political consequences. The doctrine the court relied upon is known as the Major Questions Doctrine. Over the past several years, the Supreme Court has strengthened this principle. When an executive agency claims power over issues of vast national significance, courts will not assume Congress intended to grant that power unless the statute speaks clearly. Ambiguous phrases are not enough. Broad language cannot be stretched indefinitely. In this case, the statute authorized the president to regulate certain activities during emergencies, but nowhere, the court noted, did Congress explicitly authorize the scale of action undertaken. The administration had interpreted regulate to include restructuring entire funding frameworks and suspending statutory limits. The majority found that leap unsustainable. The statute does not authorize this action, the opinion stated plainly. That sentence carried weight not because it was dramatic, but because it was definitive. The court was not evaluating whether the emergency was real. It was not minimizing the crisis. It was not disputing the need for swift action. Instead, it focused on authority. The court did not question the crisis, it questioned the authority. That distinction reshaped the entire debate. The majority explained that emergencies test constitutional boundaries, but they do not erase them. If Congress wishes to grant the president sweeping authority to override statutory limitations, it must do so explicitly. Silence is not permission. Flexibility is not infinity. Emergency does not mean unlimited. The dissent argued that the majority's approach risks tying the executive branch's hands during moments of genuine urgency. It warned that requiring hyper-specific statutory language could slow response in future crises. But the majority responded implicitly. The Constitution was designed precisely to prevent concentration of unchecked power, especially during emergencies. Crisis can expand authority temporarily, but only within the bounds Congress has set. What makes this ruling strategic rather than ideological is its consistency with recent precedent. The same doctrine has been applied in environmental regulation cases, student loan policy disputes, and public health mandates. In each instance, the court demanded clear congressional authorization for expansive executive action. This case extended that principle into the realm of emergency economic power. The message is not partisan, it is structural. The executive branch must operate within the textual grants provided by Congress. The court drew a line not around the policy, but around the interpretation. It signaled that future administrations, regardless of party, cannot rely on broadly worded emergency statutes as blank checks for sweeping transformation. If Congress wants to authorize extraordinary measures, it must say so unmistakably. That is the legal line that could not be crossed. It was not about whether the president acted in good faith, it was about whether the statute supported the action taken. The majority concluded it did not. And once that conclusion was reached, the rest followed inevitably. The emergency power was insufficient, the authority collapsed, and the constitutional boundary held. The ruling was posted at 10:18 a.m. By 10:21, the West Wing was no longer running on schedule. Meetings were interrupted mid-sentence. Phones began lighting up across the council's office. Senior advisors who had been discussing unrelated policy priorities suddenly shifted to one topic only: damage control. The emergency powers that had driven months of executive action were gone, and the implications were spreading faster than anyone had anticipated. Staffers printed copies of the 4-2-page opinion. Legal counsel circled key phrases. Major questions. Clear authorization. The statute does not authorize this action. Each line felt heavier than the last. The initial reaction was disbelief. Not because a ruling had come, everyone expected a decision eventually, but because of its breadth. This was not a narrow limitation. It was a structural rejection. The administration's legal team immediately gathered in the Roosevelt Room. Whiteboards filled quickly with possible responses. Could a stay be filed within hours? Yes. Could an alternative statute be invoked? Possibly. Could the executive order be rewritten to narrow its scope and survive judicial scrutiny? Unclear. Time mattered. Optics mattered. Momentum mattered. Meanwhile, the scheduled afternoon press briefing was quietly postponed. Reporters noticed immediately. Social media feeds began speculating. Cable networks displayed the ruling's key sentence on screen in bold letters. The White House communications director drafted a holding statement emphasizing respect for the court while expressing deep disappointment. But inside the building, the tone was less measured. This was not just a legal setback. It was a political blow. The emergency declaration had been the foundation of several high-profile initiatives. Its collapse created not just legal uncertainty, but narrative vulnerability. Around noon, the president addressed the ruling publicly. The tone was controlled at first. He described the decision as unexpected and reiterated the seriousness of the crisis that had justified the emergency declaration, but then the language sharpened. He questioned whether the court fully understood the urgency facing the nation. He emphasized that 2 justices he had appointed had joined the majority. That detail was not lost on observers. Political allies began echoing his frustration, framing the ruling as judicial overreach. Critics countered that the court had simply enforced constitutional boundaries. The battle lines formed instantly. Inside the legal strategy session, options narrowed. The first move was clear: file an immediate appeal to the Federal Circuit Court and request an emergency stay. That filing was drafted within hours. The argument centered on harm that halting the executive actions would create irreparable national damage. But appeals take time, even expedited ones. The administration could not rely solely on judicial reversal. Alternative statutory pathways were examined. Could another emergency provision provide narrower authority? Could specific funding reallocations be justified under separate congressional appropriations language? Each potential workaround carried risk. The court's reasoning had not been technical. It had been foundational. Simply swapping statutory citations would not necessarily survive scrutiny. The possibility of rewriting the executive order surfaced repeatedly. If the scope of the action were reduced, if it focused on more limited regulatory adjustments, instead of broad funding redirection, perhaps it could fit within clearer statutory language. But narrowing the order would also signal retreat. It would concede that the original interpretation had been too expansive. Political calculus intertwined with legal strategy. Every option carried consequence. By mid-afternoon, the appeal was formally filed. The administration requested that the appellate court pause the injunction immediately. The legal argument emphasized precedent, executive flexibility, and historical practice. But the deeper question hovered unspoken: compliance or confrontation? Filing an appeal is compliance with process. But public criticism of the court and aggressive rhetorical framing risked escalating into confrontation. The president's advisors understood the delicate balance. Markets were watching, Congress was watching, international allies were watching. The executive branch could challenge the ruling forcefully, but it could not appear to disregard it. Agencies had already begun halting implementation. Direct defiance was not an option, but strategic resistance was. The tension inside the White House was not chaotic, but it was urgent. Staffers moved quickly. Legal language was refined. Messaging was calibrated. The ruling had redrawn the battlefield, and the administration was adjusting in real time. For months, the emergency power had provided speed and unilateral leverage. Now the terrain required negotiation, judicial persuasion, and possibly congressional action. The shift was stark. Momentum had been replaced by scrutiny, authority by argument. Whether the appellate court would grant a stay remained uncertain. Whether the Supreme Court would revisit the issue if asked remained unknown. But one fact was clear: the presidency had been checked, and how it responded in the next 48 hours would define the political narrative. Compliance would project institutional respect. Confrontation would energize supporters but risk deeper instability. The White House was not just reacting to a court decision, it was recalculating the limits of power, and in that recalculation, the stakes could not have been higher. At 10:19 a.m., 1 minute after the Supreme Court ruling went live, trading desks in New York began refreshing their screens. By 10:23, the Dow Jones Industrial Average had slipped sharply, not in freefall, but in recognition. This was not just another political headline, this was a structural change in executive authority. Within the first hour, the Dow dropped more than 400 points before stabilizing. It wasn't panic selling, it was recalibration. Investors were trying to price something far more complicated than earnings or inflation. They were pricing power. Treasury yields moved next. The 1-0-year yield ticked downward as capital flowed into government bonds, a traditional safe haven during uncertainty. That shift signaled caution, not collapse. When authority becomes uncertain, capital seeks predictability. Ironically, the same ruling that constrained executive power was seen by some as long-term stabilizing, but in the immediate moment, uncertainty dominated. Traders were not reacting to the crisis itself, they were reacting to the legal vacuum created by the ruling. The US dollar fluctuated against major currencies within minutes. Currency markets operate on confidence in governance, in fiscal structure, in institutional continuity. A Supreme Court decision rejecting emergency authority sends a complex signal. On one hand, it affirms constitutional order. On the other, it introduces short-term policy paralysis. The dollar dipped briefly before regaining ground, reflecting that tension between disruption and discipline. But the real story unfolded beyond stock tickers. Corporate legal departments across the country began holding emergency calls. Businesses that had adjusted operations under the emergency framework suddenly found themselves in limbo. Contracts built around executive directives were paused. Regulatory relief measures vanished overnight. Federal funding pipelines froze. The question was immediate: what remains enforceable, and what does not? Industry associations issued cautious statements by early afternoon. Some praised the court's clarity, arguing that long-term investment depends on stable constitutional boundaries. Others warned that sudden reversals of executive policy create operational whiplash. One CEO summarized it bluntly: "We can adapt to strict rules or loose rules. We struggle with moving rules." Global allies were watching just as closely. Foreign governments that had negotiated agreements under the emergency framework sought clarification. Diplomatic channels activated quietly. If executive commitments were made under now invalid authority, what does that mean for cross-border arrangements? In global markets, consistency is currency. Any sign of internal institutional conflict triggers reassessment. Then there was the budget question. Billions of dollars had been redirected under the emergency declaration. If those reallocations are invalidated, could funds be clawed back? Could agencies face repayment obligations? Would Congress need to pass corrective legislation? The Treasury Department began reviewing exposure scenarios. Budget analysts examined worst-case projections. If refund claims or reversals materialize, the fiscal ripple could extend into deficit forecasts and appropriations battles. Investor uncertainty deepened not because of immediate losses, but because of timing. Appeals could take weeks. Emergency stays could be granted or denied at any moment. Markets dislike ambiguity more than they dislike bad news. A definitive loss can be priced. An unresolved legal battle cannot. At 9:47 a.m., a single federal judge did something no court has done in modern history. The courtroom was quiet when the order was entered. No dramatic speech, no raised voice, just a written ruling uploaded to the federal docket system. But within minutes, phones began vibrating across Washington, screens refreshed, staffers leaned over desks. Because the decision did not merely slow down a policy, it stopped it. Immediately, nationwide, the judge issued a sweeping injunction blocking the administration's flagship executive action, a policy that had reshaped regulatory enforcement, redirected billions in federal funds, and expanded executive authority beyond what critics had long warned was constitutionally sustainable. The ruling froze implementation across all 50 states. Agencies were ordered to cease enforcement at once. Funds already allocated were paused. Deadlines were suspended. Compliance directives were voided pending further review. The order was immediate. The impact was seismic. To understand why the reaction was so intense, you have to understand how rarely federal district judges issue rulings of this magnitude. District courts handle thousands of cases every year. Most decisions are technical, procedural, limited in scope. Even controversial injunctions are typically narrow, targeted, temporary. This was different. The language of the ruling left little ambiguity. The court concluded that the executive branch had exceeded its statutory authority and likely violated core constitutional constraints. Not possibly, not hypothetically, likely. And under federal law, that standard is enough to halt enforcement while litigation proceeds. The judge wrote that allowing the policy to continue even for weeks would risk irreparable harm to constitutional structure itself. That sentence, constitutional structure itself, sent a chill through the room. Because courts do not use that phrase lightly, the policy in question had been framed by the administration as urgent and necessary. It relied on an aggressive interpretation of existing statutes to justify expansive executive control over regulatory decision-making and financial allocation. Supporters argued it was bold leadership. Opponents argued it was executive overreach. But until 9:47 a.m., it was operational reality. Agencies had adjusted, contracts had been signed, markets had factored it in, and then, with one order, it stopped. Inside the courtroom, the reaction was restrained but unmistakable. Attorneys for the plaintiffs exchanged brief nods. Government lawyers scanned the final pages in silence. No one celebrated, no one protested. But the gravity was understood instantly. This was not a routine preliminary injunction. This was a judicial intervention of historic scale. Reporters rushed into the hallway, typing furiously. Within 10 minutes, legal analysts were on television. Within 20, members of Congress were issuing statements. And inside the White House, senior advisors were pulled into emergency meetings. Because this was not merely a legal setback, it was a structural interruption. The ruling challenged the foundation of the policy itself, not just its implementation details. It questioned whether the executive branch had the authority it claimed from the beginning. That distinction matters. Courts often review how agencies apply laws. Rarely do they question whether the authority existed at all. This judge did. That is why comparisons to routine injunctions miss the point. The order did not tweak enforcement timelines. It froze an entire framework. It did not suggest modification. It demanded cessation. And it did so with language invoking separation of powers, the constitutional principle that prevents any one branch from consolidating unchecked authority. In Washington, the reaction unfolded in layers. Allies of the administration called the ruling judicial activism. Critics called it overdue accountability. Markets, which had grown accustomed to regulatory volatility, reacted cautiously. Treasury yields dipped slightly as uncertainty returned. Major indices fluctuated. Investors recalibrated. Because whenever executive authority is abruptly constrained, economic expectations shift. Projects that depended on the policy entered limbo. Contracts faced review. Compliance officers paused implementation memos mid-sentence. The shock was not chaos. It was suspension, a moment where momentum stopped and everyone waited for the next move. Legal experts began asking the inevitable question, will this hold? The government is expected to appeal immediately. Emergency motions could reach the appellate court within days, possibly hours. But for now, the injunction stands. And standing is enough to alter the balance of power, at least temporarily. What makes this moment historic is not just the scope of the order, it is the signal it sends. Federal courts do not lightly intervene in major executive initiatives. When they do, it usually follows prolonged litigation and incremental rulings. This came swiftly, directly, unambiguously. It suggests a judiciary willing to reassert boundaries when it perceives constitutional strain, and that reassertion carries consequences beyond this single policy. Because once one aggressive interpretation of authority is checked, others are scrutinized. The ruling that stopped Washington cold may prove to be more than a pause. It may be the first crack in a broader legal theory of executive expansion. At 9:47 a.m., a federal judge drew a line. The order was immediate, the impact was seismic, and what follows may redefine the limits of presidential power for years to come. To understand why the ruling landed like an earthquake, you have to step inside the reasoning, because this was not an emotional decision, it was not rhetorical, it was methodical. Page by page, citation by citation, the judge built a legal argument that dismantled the administration's authority claim at its root. The shock did not come from dramatic language. It came from constitutional structure. At the center of the opinion was Article 1 of the Constitution, the section that vests legislative power in Congress. The judge began there deliberately. The executive branch, the opinion explained, does not create law, it executes it. Agencies do not invent authority, they derive it from statutes passed by Congress. That principle sounds elementary, but in moments of aggressive policy expansion, elementary principles become decisive. The administration had argued that existing statutory language granted broad discretion to implement the challenged policy. It relied on phrases like necessary and appropriate and in the national interest, interpreting them as expansive delegations of power. In ordinary regulatory matters, such phrasing often allows agencies flexibility, but the judge framed this case as extraordinary. The policy, the opinion noted, carried vast economic and political consequences. It redirected billions of dollars. It altered enforcement priorities nationwide. It redefined how agencies exercise discretion. When consequences are that large, ambiguity is not enough. That is where the major questions doctrine entered the analysis. The doctrine, developed and strengthened in recent Supreme Court decisions, holds that when an executive agency claims authority over issues of major national significance, Congress must speak clearly. Courts will not infer sweeping power from vague statutory text. The judge applied that principle directly. If Congress intended to grant the executive branch this level of unilateral authority, it would have said so explicitly. It did not. Therefore, the claimed power could not stand. The administration countered that urgency justified flexibility. National challenges require swift response. The statute's language, they argued, was intentionally broad to accommodate unforeseen circumstances. But the opinion rejected that reasoning as structurally dangerous. Urgency does not erase separation of powers. Flexibility does not mean infinity. The Constitution divides authority precisely to prevent concentration during moments of pressure. The judge cited separation of powers explicitly, the foundational doctrine that allocates legislative power to Congress, executive power to the president, and judicial power to the courts. When one branch expands beyond its textual grant, the others must respond. That is not hostility, it is design. The ruling also invoked administrative law principles. Agencies must act within the bounds of statutory authority. When they exceed those bounds, courts may declare their actions ultra vires beyond their legal power. That term appeared in the opinion with deliberate weight. By labeling the policy ultra vires, the judge was not merely adjusting its implementation, he was declaring it legally unauthorized from inception. That distinction elevates the ruling from disagreement to disqualification. The administration further argued that no explicit constitutional clause prohibited its action. The judge responded by reframing the burden. The question is not whether the Constitution forbids it. The question is whether Congress permitted it. Executive authority is not presumed. It must be granted. That inversion is subtle but decisive. It shifts the analysis from defensive to foundational. The opinion also referenced due process concerns. Rapid implementation of sweeping policy without clear statutory backing can create arbitrary enforcement, uneven application, and legal uncertainty. Due process requires predictability and fairness in how laws are applied. When authority itself is unstable, predictability collapses. That risk, the judge argued, justified immediate injunction. Legal scholars have already begun calling the ruling unprecedented, not because courts have never issued injunctions before, but because of the reasoning's breadth. It did not merely fault procedural missteps, it questioned the architecture of delegated authority. It applied modern Supreme Court doctrine at the district court level with remarkable directness, and it did so against a policy that had been politically defended as essential. That combination, scale, doctrine, immediacy, is rare. The key line circulating among analysts captures it precisely. This wasn't policy disagreement, this was authority denial. The court was not saying the policy was unwise, it was saying the policy was unauthorized. That is a different category of judicial intervention. Policy can be revised. Authority must be rebuilt. The administration believed it possessed sufficient statutory grounding. The judge concluded that grounding was insufficient for the magnitude of action taken. That disagreement now defines the legal battlefield. Appeals will follow. Arguments will intensify. But the foundation of the shock remains simple. The Constitution allocates power deliberately. Congress writes the law. The executive executes it. When execution transforms into expansion, courts step in. This ruling did not invent a new doctrine. It applied existing ones with force. And that force is what makes the moment historic. To understand why legal scholars are already calling this ruling not seen in modern history, you have to zoom out. Because federal judges issue injunctions all the time. Policies get paused, regulations get revised, agencies get sent back to the drawing board. That is normal friction inside a constitutional system. What happened here is different. This was not friction, it was structural interruption. The closest historical parallel begins in 1952, in the middle of the Korean War, when President Harry Truman ordered the seizure of American steel mills to prevent a labor strike from disrupting wartime production. Truman argued that national security justified executive action. The Supreme Court disagreed. In Times, Youngstown Sheet and Tube Co., Sawyer asterisk. The court ruled that the president could not seize private industry without explicit congressional authorization. That case became the modern boundary of executive emergency power. It is taught in every constitutional law course in the country, and what makes the current ruling comparable is not ideology, it is scale. In both cases, the executive branch claimed urgent authority rooted in broad necessity. In both cases, the judiciary responded by pointing back to Article 1 Congress writes the law. In both cases, the court intervened not because it disliked policy, but because it found the authority insufficient. That is rare territory. Move forward 2 decades to the Watergate era. In Times United States v. Nixon *, the Supreme Court unanimously ordered President Richard Nixon to comply with a subpoena and release the White House tapes. The court acknowledged executive privilege but rejected its absolute application. The message was clear: not even the president is above judicial review. That ruling did not block a policy, it enforced accountability. But like the present case, it marked a structural boundary. It reminded the presidency that institutional limits are real. That kind of moment does not happen often. Fast forward to the travel ban litigation during the early months of another administration. Federal district courts issued nationwide injunctions blocking executive immigration orders. Those cases generated headlines and fierce political debate. But even there, the Supreme Court eventually allowed a revised version of the policy to proceed. The legal battle was about application and discrimination standards. It was not a wholesale declaration that the executive lacked foundational authority to act in the domain of immigration. The present ruling goes further. It does not simply refine enforcement criteria. It challenges whether the executive branch possessed the statutory power at all. After the 11th of September 2001, courts reviewed emergency detentions, surveillance expansions, and national security measures. In cases like Times Hamdi v. Rumsfeld, Times and Times Boumediene v. Bush *, the Supreme Court affirmed that even in wartime, constitutional protections apply. Those rulings were historic because they limited executive authority during crisis. Yet they often came after years of litigation and Supreme Court review. The present case reached a structural conclusion at the district court level. That immediacy is what makes analysts pause. Federal district judges rarely draw lines this boldly against flagship executive initiatives. Injunctions happen, but injunctions of this magnitude, rooted in major questions, doctrine and separation of powers reasoning against a policy carrying enormous economic and political weight, are exceptionally uncommon. This was not a technical pause while paperwork is corrected. It was a declaration that the underlying authority was likely invalid. That difference elevates the ruling beyond routine judicial oversight. It enters constitutional history. Consider the financial implications alone. When executive power is curtailed at this scale, markets recalibrate. Agencies halt billions in projected allocations. Private sector contracts hang in suspension. Investors reassess regulatory risk. That kind of systemic ripple is usually triggered by Supreme Court rulings, not district court injunctions. The fact that this began at the trial court level underscores the strength of the legal reasoning involved. This is why legal commentators describe it as structural. Structural moments reshape assumptions. They redefine what is considered possible. For years, executive authority has expanded through incremental interpretation. Each administration tests boundaries. Each Congress delegates broadly. Courts often defer. This ruling signals a potential shift in that pattern. It suggests that lower courts are willing to apply the Supreme Court's recent doctrinal tools aggressively. That changes incentives across the federal government. Agencies will draft regulations more cautiously. White House counsel will scrutinize statutory language more closely. Congress may be forced to legislate more explicitly. These are long-term consequences. And long-term consequences are what define historic rulings. This is not simply a court fight between partisan camps. It is a recalibration of constitutional balance. When judges question authority at its root, the system adjusts. That adjustment is rarely comfortable. It produces appeals, political backlash, and economic hesitation. But it also clarifies boundaries. And clarity, even when disruptive, stabilizes over time. The ruling stands now as a marker, a moment where a federal judge applied constitutional doctrine with unusual breadth and immediacy. Whether it survives appellate review remains to be seen, but its existence alone signals something profound. The judiciary is willing to draw lines that had long been assumed elastic, and in American constitutional history, those moments are few and far between. Federal courts do not often draw red lines this bright. The injunction was filed at 9:47 a.m. The counterattack began before noon. By early afternoon, the Department of Justice had formally submitted a notice of appeal to the Federal Circuit Court. The language was sharp. The ruling, the filing argued, represented a profound misreading of statutory authority and an improper intrusion into executive discretion, but the appeal was only the first move. Within hours, government attorneys also requested an emergency stay, a procedural mechanism that, if granted, would temporarily suspend the district court's injunction while the appeal proceeds. In practical terms, a stay would restore the policy immediately. Agencies could resume enforcement. Funds could move again. Momentum would return. That request now sits before the appellate judges like a loaded question. Do they allow the policy to restart, or do they let the freeze remain? The answer will signal how higher courts view the district judge's reasoning. Behind closed doors, administration lawyers began exploring parallel pathways. If the appellate court declines to grant a stay, the next stop could be the Supreme Court. Emergency applications can move quickly, sometimes within days. The justices would then face a narrow but explosive question: does the district court's reasoning justify nationwide suspension of a major executive initiative? This is where strategy becomes layered. Appeals are not only about winning, they are about timing. The longer the injunction stands, the more disruption spreads. Contracts remain paused. Political narratives harden. Investors factor in delay. That pressure can influence judicial calculus. Speed matters, but so does clarity. Simultaneously, policy advisors floated another option: rewrite. If the court objected to the breadth of statutory interpretation, could the executive order be narrowed? Could its language be adjusted to fit more comfortably within congressional delegation? Revisions would not concede defeat. They would signal adaptation. The question is whether adaptation would satisfy the underlying legal objection. Because the district court did not merely critique implementation details, it challenged authority at its core. Adjusting phrasing may not resolve that structural critique. Congress now enters the equation. Lawmakers who had remained on the sidelines are being asked whether they will codify the disputed authority explicitly. If Congress amends the statute to grant the executive branch the precise power the court found lacking, the constitutional debate changes dramatically. But that requires votes. It requires political consensus, and consensus is not guaranteed. Some members may see an opportunity to assert legislative primacy. Others may resist expanding executive reach further. The legislative branch holds the cleanest solution, clear statutory language, but also the most politically complicated one. So the tension sharpens around a central question: is this compliance or confrontation? By appealing, the administration signals disagreement but operates within judicial procedure. That is compliance with process. But the tone of the response, the framing of the judge's ruling as overreach, the urgency of emergency stay requests suggests confrontation with reasoning. The dual posture is strategic: accept the procedural path, reject the substantive limitation. That dynamic will intensify if the appellate court sides with the district judge. An affirmation would deepen the setback and strengthen the precedent. Markets would interpret it as validation of judicial constraint. Political allies would escalate rhetoric. Pressure would mount for Supreme Court intervention. If the appellate court overturns the injunction, the balance shifts again. Agencies would restart the policy. The district court's reasoning would weaken. Critics would frame the reversal as restoration of executive authority. But even an overturn would not erase the structural debate. It would only relocate it to the highest court if further appeal follows. And if the Supreme Court steps in, the stakes elevate to historic proportions. A stay granted by the justices could revive the policy instantly while full review proceeds. A denial could freeze it indefinitely. Either outcome would shape constitutional doctrine for decades. The speed of escalation suggests that this dispute will not linger quietly. It is climbing. Each judicial rung carries greater institutional consequence. District Court, Circuit Court, Supreme Court. With every step, the arguments sharpen and the implications broaden. Legal scholars are already drafting amicus briefs. Industry groups are positioning themselves. Advocacy organizations are preparing filings. This is no longer a single injunction in a single courtroom. It is a national test of delegated power. The next decision, whether on a stay, an appeal, or a rewritten order, will signal how firmly the judiciary intends to hold the boundary it has drawn. The administration is betting that higher courts will see overreach in the injunction itself. The plaintiffs are betting that constitutional restraint will prevail. Between those bets lies uncertainty, and uncertainty amplifies tension. Because once litigation accelerates at this level, outcomes arrive quickly and echo loudly. The injunction may have stopped Washington cold. The appeal has restarted the engine, and as filings move upward, one reality becomes clear: this fight may be moving up the judicial ladder.